Good evening. I'm David Ferriero, the Archivist of the United States, and it's a pleasure to welcome you to the William G. McGowan Theater here at the National Archives on this, the 227th anniversary of the signing of the United States Constitution. And I also want to welcome those of you who are joining us on YouTube. Tonight, we'll engage in a conversation about the state of the Constitution. Is the Constitution still working for America? Our panel of experts will explore the relevancy of the Constitution and look at court cases and proposals to amend the Constitution as well. Our program tonight is presented in partnership with the Center for the Constitution at James Madison's Montpelier in Orange, Virginia, about 30 miles north of Charlottesville. This is our 5th year of partnership with the Center and our hosting of the annual Claude Moore Lecture. On behalf of the Archives, I'd like to thank Kat Imhoff, President and Chief Executive Officer of Montpelier Foundation, Sean O'Brien, its Executive Vice President and Chief Operating Officer, Kimberly Skelly, Executive Vice President for Advancement, and Doug Smith, Montpelier Vice President for the Robert H. Smith Center for the Constitution. Before we go any further, I'd like to tell you about 2 upcoming programs here in the McGowan Theater. Next Tuesday, September 23rd at 7 p.m., we'll present the 8th annual Charles Guggenheim Tribute Program by presenting the Oscar-nominated documentary of the D-Day invasion in Normandy in World War II, narrated by David McCullough. The screening will be introduced by Craig Simons, author of Neptune, the Allied Invasion of Europe and the D-Day Landings. Then on Thursday, September 25th at 7, we'll present the film Breath of Freedom, the story of the 1 million plus African Americans who fought in World War II and whose fight we continue back home on American soil. Following the screening, there'll be a discussion including Dr. Frank Smith Jr., Director of the American Civil War Memorial and Museum. The program is presented in partnership with the Congressional Black Caucus Legislative Conference. To learn more about these and all of our programs and exhibits, there are copies of our monthly calendar of events in the lobby, as well as sign-up sheets where you can receive them in the mail, regular mail, or by email. And you'll also find brochures about other National Archives programs. And another way to get more involved with the National Archives is to become a member of the Foundation for the National Archives. The Foundation supports all of our education and outreach activities, and there are application forms also in the lobby. And a little secret, no one has ever been turned down for membership in the Foundation. The Constitution of the United States has endured now for 227 years with very few changes. It's been amended only 27 times, and one amendment repealed another, the 2 dealing with prohibition. Other amendments have been proposed but could not get the approval of 3/4 of the states for ratification. One of them, the 27th and the newest, was proposed in 1789 as part of the Bill of Rights, but not approved by 3/4 of the states until 1992, more than 202 years later. It requires that any increase in the salary of members of Congress not take place until a new House of Representatives is elected. The original Constitution, in case you need to be reminded, is in an airtight, state-of-the-art encasement in the rotunda upstairs. And I invite you all to come by during regular museum hours and take a look if you haven't. This morning we did a naturalization ceremony in the rotunda, 35 new American citizens standing in front of the Constitution. Now on with our program. Doug Smith is Vice President of the Montpelier Foundation, overseeing the Robert H. Smith Center for the Constitution. Doug is the former CEO and President of the Virginia Interfaith Center, where he led the creation of one of the most well-known state-based policy centers in the country. He's also the former chairman of the board of Heifer International and was named a fellow of the Sorensen Institute for Political Leadership at the University of Virginia. To introduce our distinguished panel, please welcome Doug Smith.
Well, good evening. Throughout this week, and especially today, Constitution Day, communities across the country have been celebrating this Charter of Freedom, the U.S. Constitution. and we are so pleased to be here with the National Archives for what is one of the nation's capstone events for Constitution Day. David, we are so pleased to have this partnership in so many years now, 5 years in, and we look forward to continuing that for many years to come. I want to welcome you to the McGowan Theater at the National Archives and welcome those who are joining us on the web. We're being live streamed this evening. There should be ample conversation towards the end of our program. And when we get to that point, and I will encourage you to bring questions for the panel, let me encourage you to go directly to the microphones on each side of the theater where you'll have a chance to ask questions of the panel. So please join me in inviting our distinguished panel this evening, the Honorable Robert Hurt. He represents the 5th District of the U.S. House of Representatives. He's a member of the Financial Services Committee. He's on the Housing and Insurance Subcommittee. Akhil Reed Amar of the law school at Yale. I call him America's favorite con law professor. Akhil, welcome. And Ben Wittes, our dear friend from the Brookings Institution and the Lawfare blog. Ben, welcome to the stage. Okay, gentlemen, the question for the night. Is the Constitution still working for the United States? Is it still working for the people? Let me start with you.
Doug, thank you. And let me first of all thank the National Archives for hosting this tonight. What a fantastic opportunity. For those who are watching on the web, I certainly would encourage anybody, I imagine everybody here has been to the National Archives before, but for those who haven't, obviously, you need to come and see these documents and so much more that's here. But I want to thank the archives, and then I also want to thank the Center for the Constitution, Sean and Kat and Doug for the invitation to be here and for what you all do to promote the Constitution and understanding of that. And then finally, I want to certainly thank our fellow panelists. I'm delighted to be here with you all, and thank each of you all for coming on this important day. And many of you, I believe, are from Virginia's 5th District, my home district, and so we're especially delighted that you're here. But with all that said, I would say unapologetically and a resounding yes. I think that the Constitution is viable. I think that the Constitution is viable because the principles that it's founded upon. And I think that James Madison, as we know from if you ever visit Montpelier, read your history, you know that the principles that this country were founded on, freedom, liberty, individual liberty, the idea that we have the checks and balances that are built into our Constitution, all those things are as important today as they were in 1787, as they were in 1776 when we had the Declaration of Independence signed. And so I believe that it is viable. And I guess, you say, well, how do you judge viability? Well, that's hard to do. I would say this, I would agree, and I would imagine anybody who is an observer of what takes place in Washington would say, well, the Constitution may not be viable, but certainly, may be viable, but certainly the people that are in charge of interpreting it and in charge of following it often have a hard time. I would agree with that 100%. And I think that is true. But I think when you go out to the countryside, when I got out of law school, I was a prosecutor in the small town where I live, a little courthouse town in Southside Virginia. And it always, after studying law and studying the Constitution in law school, which was a fantastic opportunity and a fantastic education, to be able to come back and to go to Pittsylvania County General District Court on Monday morning. That is where the rubber meets the road when it comes to the importance of our freedoms. Fourth Amendment issues. They come up every single day in General District Court. Why, officer, did you stop this car? Why did you arrest this person? Did you have probable cause? Did you have a reasonable articulable suspicion to stop them? That all comes from our Constitution, and we often take it for granted. But those things are argued, and those protections are employed every day. And I think about, who's in charge of policing that? Well, judges are, lawyers are, the police. The police spend a tremendous amount of time learning what the law is in a civilized society. Isn't that wonderful? Isn't that kind of what it's all about? And then I'll just wind up by saying this. I think also, a lot about the fact that, first of all, we have men and women who go across the world to defend this and are willing to die for our Constitution and the principles they represent. I think that's a pretty good indication of viability. But I also would say, finally, that oftentimes when I vote on the House floor, I'll come off the east front of the Capitol and come down, especially in the summertime, you come down those steps, and the plaza is totally filled with people who have traveled from every town, every county, every state in this country to come see this Capitol. As dysfunctional as it often seems. You have people from probably every country in the world that have come to visit this country, and oftentimes are out there, and I don't understand anything that they're talking about because they're speaking in foreign languages. Why are they here? Are they here because it's a beautiful building? It's a beautiful building, but they're not here for that. They're here for the principles that are contained in the documents that are in this building, and that to me, I think also signifies that our Constitution is alive and well. There are things that I think that we can all do better, but I believe that it's viable.
And these are phenomenal comments. You're a lawyer. Mm-hmm. You served as a state legislature, in the state legislature. Now you're in Congress. I mean, I think your perspective is great. We're going to come back to that. But before we do that, let me bring Akhil Amar in here, the Sterling professor at Yale. Akhil, you're watching the cases that are coming down from the Roberts Court and moving up their way through the judiciary on the way to the Supreme Court, whether the court chooses to hear those cases or not. What are some of the most important cases that should be on our radar today that serve as a little bit of a litmus test or a flashpoint about the conversation about today's Constitution?
Well, thanks. I want to echo your very thoughtful words. We're very grateful to be here. Thank you all for coming, and thanks to the archives. Some of the most important dogs are the ones that don't bark, Sherlock Holmes tells us. So just in the in past, the biggest thing that the Supreme Court did was actually not invalidate a major piece of legislation, Obamacare. Very controversial. People are of different views. Judicial review, my teacher Charles Black reminded us, is also, it's not just the power to strike something down, it's in effect the power to validate. Precisely because a court can strike it down. If it doesn't, and if people on the court, after looking very carefully at the issue, say this is okay, that achieves a certain legitimation in a country where there is disagreement. So all honor to John Roberts. You see, he's a Republican appointee, and he voted to uphold that. That was a big one. So it would have been very big the other way, and so big that we sort of forget what didn't happen, which is the fundamental legitimation of Obamacare. Here's another dog that might not bark. Whether you like it or not, gay marriage is coming to a theater near you everywhere very soon, whether the Supreme Court gets into the act or not, because stuff is happening bottom up. Even Virginia is changing, just even in the last year, lots of stuff going on there. And this fruit might sort of drop, this ripe fruit, even without a Supreme Court intervention, because ours is a society in which people can advocate for new rights. The Ninth Amendment talks about new rights, the rights of the people. Not all of them are given to us from on high, from judges. Some of them are earned bottom up. So some of the biggest things that might happen are dogs that don't bark. Let me say one final thing, just because I can't resist on the broader question about whether the Constitution is working. Just take one step back, because I know times are tough for lots of folks, but take a step back. 227 years ago, basically none of the world was democratic. Okay, we're almost the only democratic project going in the world. On September 17th, 1787. There's us, Britain to some extent, Switzerland, that's it. That's it. Now half the planet's democratic on the American model, with written constitutions and multiple parties and free and fair elections and religious toleration and free speech and minority rights and the rule of law in Europe and India, a across half the planet. We won the last century. I like our odds for this one. And it's on the American model. We are winning. We are winning. And part of what winning means, actually, is the rest of the country comes closer to us. That's what success means, when the world is becoming American. And America is becoming more global. So, and we have our problems, but by the way, so does everyone else around the world. And I still basically think that we remain the indispensable nation. We weren't actually in 1787 quite. We had an idea, but the military, political, economic, cultural, legal success of the United States Constitution is basically one of the biggest facts of the last 227 years.
Well, Ben, I think Akhil just threw the gauntlet down a little bit. Ben Wittes with Brookings Institution, the Lawfare blog. I mean, you're intimately familiar with national security issues and governance. What do you think about what Akhil is saying here? I mean, do we have the tools we need to maintain ourselves as a 21st century superpower?
Well, would you take a yes and no? First of all, I'm actually not going to echo all the thanks, only because I don't want to take up time. So consider them incorporated by reference. Look, there is a very distinguished line of thought, perhaps most pithily encapsulated by Judge Richard Posner, that the Constitution is not actually adequate to contemporary national security challenges. And Judge Posner, I think, said it in an interview with me, actually. And the line is, the Constitution is old and short. And this is actually, I think, a deep insight and a deep challenge. So if you look at, has anybody here actually read the Maastricht Treaty, which is sort of the closest thing the EU has to a constitution? Right, there's a reason. Let the record reflect that the no hands went up. And there's a reason for that. And if I ask this audience, can anybody here quote a single line from it? I'm going to get the same answer. And the answer is because the Maastricht Treaty is new and long, right? And it actually reads, if you actually spend any time with it, it's turgid. It reads more like the Code of Federal Regulations than like the US Constitution. And you can't actually find in it anything that resembles what you would call a principle. It's a set of, and this isn't a criticism of it. It's actually just an observation. It resembles, it is a list of agreements and working operational structures for an existing set of states to cooperate. The Constitution doesn't read like that. And by the way, where it does, those are the parts we don't remember. So people, like everybody remembers the First Amendment, people don't tend to focus on the Seventh Amendment, right? And the reason is that the Seventh Amendment creates civil trial by jury if the amount in controversy exceeds $20, right? And there's something not so timeless about, about a non-inflation adjusted, dollar figure. And what we remember about the Constitution is that and the reason it remains viable over these very, very long periods of time is that it creates rules of permission and restraint, and that it creates structures for democratic polities to make decisions and assign accountability for those decisions. Now, in the immediate post-9/11 period, I think Judge Posner's observation was a very plausible one that, hey, we're flying scary flying robots and killing people with them. There's no scary flying robot clause of the Constitution, right? The only thing the Constitution has to say about surveillance is that it should be reasonable, or that it should not be unreasonable, and that you generally need a warrant except when you don't. it says that Congress has the power to declare war, but by the way, the president also is the commander-in-chief. There are these sort of very broad and very non-specific ideas. Congress has the power to make rules of capture on land and sea. So you say, well, that's a really, what does that mean? Then there's the letter of marque and reprisal clause, right? There are these general ideas, and there's nothing like a specific code of regulations in it. And you say, going forward, where we're going to have scary flying robots, where we're going to all be carrying around cell phones that are communicating with each other constantly, and all of those communications are interceptable, all the data that phone generates is interceptable. We don't have a humans turning into cyborgs clause of the Constitution either, right? And so you have all these problems that we face as a result of developing technology, as a result of globalization, as a result of really scary people around the world. There's no really scary people around the world clause of the Constitution either. And sort of when can you not follow the normal rules because there are these guys beheading people in Iraq, right? There's no guys beheading people in Iraq clause of the Constitution. And so I think it was a very plausible hypothesis that the Constitution actually didn't address enough issues to be viable for the problems that we face. So that's the bad news. And the good news is I think Judge Posner is wrong. And I think you can look and say the Constitution doesn't provide specific answers to very many questions, actually. That's not what it's for. It's there to constitute a government that then, within certain bounds, has a lot of flexibility to address those questions. And it creates accountability mechanisms. So right now, as we speak, there is this fervent debate going on between the executive branch and the legislative branch over whether the president has the authority to go after ISIL, ISIS, IS, whatever you want to call it, and what role Congress should or shouldn't play, needs to play, must play in authorizing what the president wants to do. Why are they having that conversation? The military would follow the president's orders if Congress said nothing on the subject. And the answer is because the Constitution sets up these modes of accountable decision-making, and we have so internalized them that they infect everything we do in the national security space, even when we're not aware of that they're doing it. So one further example, and then I'll shut up. A year and a half ago, Edward Snowden releases a whole lot of information about the operations of the most secret agency in the United States. And what has happened since then? The judiciary has taken on a large number of cases brought before it, challenging the propriety under both statutory and constitutional law of lots of the programs that Snowden revealed. The executive branch has unilaterally revised a bunch of policies, asked Congress for legislative changes to impose certain new restraints, to grant certain new permissions, to change certain programs. And Congress, both houses of Congress have really spent a lot of time thinking about what parts of these programs they want to authorize, what parts they want to curtail, and what parts they don't want to address at all. These are all, none of these events had to happen. They are all reflections of a system of a set of accountability mechanisms that are endemic to the system, and that's despite the fact that there's no, bulk metadata collection clause of the Constitution.
Yet, of course. So Robert, Ben's raising an interesting point here. I mean, earlier today, your colleague, Senator Tim Kaine, actually suggested, and I think he's actually filing some legislation that you may have had a chance to briefly look at, that would essentially repeal and replace some early 2000s authorizations for war. Now, this is Tim Kaine, who was governor of the Commonwealth of Virginia, one of the first supporters of Barack Obama. Often whispered that he might actually be within the Obama administration, but ended up being head of the DNC for a time. What does it mean that someone like Tim Kaine is actually asking to constrain the powers of President Obama? Is this an adjustment because of an expanded executive that a lot of people have been talking about, or is this something else?
Well, I can't speak for Senator Kaine. I have worked with him when I was in the state legislature and have enjoyed working with him since he's been here in Washington. I will say that I believe that this is something that has interested him before he ever came to the United States Senate. He and Senator McCain have worked on the War Powers Act, the issue of the War Powers issue together. And I couldn't agree with him more. I think absolutely under these circumstances that the president needs to get authorization from Congress before he acts, and I hope that he will. I think that if you look at the Constitution and you look at the War Powers Act, which I think the White House doesn't necessarily recognize, I think you see that clearly the intent is that Congress has to make those decisions. Why? Because at the end of the day, these decisions affect each and every American citizen, and I think if you look back at the experience of not just our soldiers, obviously, who are putting themselves in harm's way, but every American citizen, the taxpayer that has to pay for it. These are things that should be debated in a candid, honest way with the American people and being able to provide input along the way, and that's what the whole purpose of Article 1 and the Congress is to be a representative for the people. Now, in my mind, I think that we want our president, especially because of the technological, war is different in 2014 than it was in 1787, to be sure. And with that said, clearly the president needs to have the flexibility to do what he needs to do to defend our interests wherever at a moment's notice. But at some point, it seems to me that it is extremely important for him to get that authorization. I think, and I would be interested in the panel's opinion on this. I believe that the earlier Iraq resolution does not cover him. I don't think that it does. And there's of course, and Mr. Kaine's his resolution deals with this issue of what does it mean to be associated with Al Qaeda? Does ISIL does that meet that definition? And I'd be interested to know you all's opinion on that. But I don't think that it does cover it. But even if the earlier resolution does give him the authority to go back into Iraq, a different group, give him the power to go into Syria, because these are somehow associated, I think that he has a moral obligation to come to the American people and make his case in Congress, and so I feel very strongly about it.
Gail, do you want to hop in here?
And I want to praise Senator Kaine for his leadership on it. Excuse me. Thank you.
I'm not a particularly big fan of the War Powers Resolution. I don't think it's drafted so well. Marty Lederman has some interesting postings. You could read them, trying to make the case that the authorization of the use of military force would permit what's going on. But I agree with you that even if it does, I think it's very healthy to have the first branch of government, the branch mentioned first in the Constitution, the branch closest to the people, the branch elected most frequently by the people, so closest in time to the last election, weigh in on this thing. And so I think that's wonderful, healthy. What did Ben say earlier? He said so much about the Constitution you just take for granted. Here's an amazing thing we take for granted. We hold elections every 2 years, come hell or high water, like in the middle of civil wars. They don't do that other places, even great places like, let's say, Great Britain, which may be in the middle of a secession right now. We're not having that, okay? But from 1935 to 1945, there was no parliamentary election whatsoever. no, people didn't vote for Winston Churchill. It was actually just a shuffling of musical chairs within the government. Between 35 and 45, there was no general parliamentary election. They just postponed elections. We don't do that here, even in the middle of civil wars. There's going to be an election. I think it's wonderful that the people's representatives are debating this. And even if there is formal power that the president has, I think it's not well used if Congress is not on board on this, because those things generally don't end well. One final, biggest problems that we face, just again for some perspective, we've got lots of challenges around the world. Just to remind you, 200 years ago this week, this place burned to the ground. Okay, so one big question is this a threat to the homeland? Is this over there? Is it somewhere in between that? But I welcome this great congressional debate, which is connected to a great debate among the citizenry that is called the November election, and we hold them, and that's not to be taken for granted, but we do, because the Constitution has succeeded. You don't even think, oh wow, that's interesting. They're going to hold an election in November.
Well, so I'm in a slightly awkward position here, actually, because I actually consulted with Senator Kaine about the legislation he introduced today, and so I'm a little bit awkwardly positioned to address this. A few thoughts. Number one, I have been one of the people, and I have taken a lot of criticism over the last several years for being generally supportive of the administration's vision of what it means to be an associated force with Al-Qaeda covered by the 2001 AUMF. I and my co-bloggers who have taken that view were all shocked by the proposition that you could conduct a major campaign over a protracted period of time against ISIL on the basis of the 2001 AUMF. I think that is, and I say this as somebody who has very energetically defended prior claims that, for example, AQAP, Shabab, various entities in the AFPAC region were plausibly understood as associated forces. I find the administration's contention here very difficult to defend, and I won't defend it. So that's, I think I think it's the idea that you would have a sustained military campaign without a congressional authorization here is, I think, troubling and disturbing. And it's an interesting thing that we don't talk about it in the language of, shock at executive power that we would talk about it, say, if this were Dick Cheney. There is actually, it's an interesting sort of hypocrisy in our political system that the most extravagant, unilateral, overseas war powers claims actually aren't made by the people who have the broadest theoretical understanding of war powers, right? So the great overseas military adventures of the Bush administration are all very specifically congressionally authorized. This one is not. The Libya one was not. The Kosovo one in the Clinton administration was not. And I think we have a way of letting the people who, in fact, believe in less robust assertions of executive authority in the war powers arena get away with making, in fact, much broader ones in this particular space than we do the people who are actually advocates of broad executive power. I want to say one word about Senator Kaine in this. He and I, there are a lot of things that, we're not from similar political space about. his attention to this issue is a model of the way legislators ought to behave. And he has been deeply personally engaged with, at a very granular level, with the details of what Congress should and shouldn't be doing at the level of statutory language, at the level of, at a theoretical level and at an operational level, what specific activities do you and don't you want to be authorizing? And the quality of the thought that has gone into some of the work that he's done, we often sit around, and I do it myself, you look at the quality of leadership that this country had at the time of the drafting of the Constitution and the first few generations, and you say, and certainly the poll data reflects that. I mean, when Congress has a 6 or 9% approval rating, and on a good day, 13 or 14%, right? People aren't sitting around with enormous admiration for their leadership. And the president has a 40% approval rating, which is very low, of course, for a president, but it's dramatically higher than his interlocutors in most of these conversations. I have and this debate over ISIL and authorization is one in which has not shrouded either the legislative or the executive branch in glory, right? The executive branch is basically saying, well, first of all, the president said a year ago we need to move to end the war and repeal the AUMF, and then turns around and has an extravagant view of what it incorporates. And Congress's institutional posture is just don't make us vote before the election, which is, hardly an attractive posture. That said, there are people who are doing the work that you would want legislators to do in the fashion that you would want legislators to do them. And I read the Kaine proposal. You may disagree with parts of it. You may agree with parts of it. It's not the bill I would have written if I had been a senator. There's a lot of good thought in it.
Ben, you brought up the polling, and I don't think we want to govern by poll, certainly. But admittedly, Congress is at a 14% approval rating, which is 5% higher than it was last year at this time.
Well, the government's open this year.
And there's I think it would be fair to say there's a general feeling that things are broken. Nothing's getting done in Washington. And so I wonder, is that really the truth, or is that just the spin of media organizations? Or maybe that's just how the system is constructed in the first place. I wonder if any of you would be willing to comment on that after Congressman Hurt.
Yeah, we have a member of Congress here.
No, I think that no, certainly people are not pleased. As one person has quipped to me recently, said, "I'd like to know who those 14% are. They're probably not in this room. If they are, they won't admit it." But certainly Congress deserves the reputation that it's got. There's no question about that. It is interesting, though, just to put things in perspective. While when we have the elections in November, I would imagine, even though Congress is at 14% approval rating or whatever it is, most of them are going to come back. Most of them will get reelected, and everybody hates Congress, but they love except for their congressman, and that's sort of axiomatic, I think. But I do think, I'd just say a couple of things. I mean, I think that, first of all, politics, because of the media scrutiny, certainly the partisan nature of politics, the money that's involved in the campaigning, it's a nasty business. It can be nasty, and we don't like that it's nasty. But I think that it certainly It's very hard from that standpoint. And I can tell you, coming from Richmond, and of course I've known you since I was in Richmond, to come from that perspective where, frankly, most of the issues that we ever worked on in committee, on the floor, we had robust open debate, unlimited debate. You had the unlimited opportunity to be a part of the conversation. Things weren't under closed rule. You know, your bill got heard by a committee, whether the chairman wanted it heard or not. Now, only, you know, it might have been at 7:30 in the morning and only 3 people show up. And it might be promptly killed, but there was to legislate was a verb. Here, it's quite different. I guess I would say that I think that I don't think that the Constitution is broken. I think that the people that are supposed to follow it don't do the way that they're supposed to, and I think that we see the result of that. I do think that our founders absolutely wanted the legislative process to be hard. There's no question. It needs to be hard if you look at the path a bill has got to take. And I think that they wanted it to be hard. There's no question about it, because that protects ultimately the individual citizen, I think they would argue. I think that's for sure. So I think they did want it to be hard. I would also point out this, you know, it's so great that we're all here celebrating the Constitution on, was it 227th birthday of the United States Constitution. We're all here, and out of everybody here, we would all say we love the Constitution. We're so glad to be here to celebrate the birthday of the Constitution. But think back to 1787. When it was adopted, it wasn't everybody. It was 39 of the 55 delegates actually signed it. So there was a tremendous acrimony at the time. And then you think about the Virginia debates, where Patrick Henry debated James Madison in Richmond as to whether or not Virginia should ratify this Constitution. I think that the vote on that, it was a horrendous fight between Patrick Henry and James Madison, the anti-federalists versus the federalists. I think it was 87 to 78. It was 89 to 79. I mean, that was not, I mean, it's kind of remarkable that we're all here talking about how great the Constitution was, because about half of the people back then thought it was in Virginia, thought it was a terrible idea. And so I say that we, you know, sometimes we need to take things in stride when we see all of the acrimony, because I think our Constitution can withstand it.
And not just in Virginia, it was 30 to 27 in New York, and it was very close in Massachusetts and New Hampshire. Now here's, and Congress deserves today a bunch of blame, but here's another truth, and members of Congress may not tell you this because you'll just hate them more, even though it's true. No, the people deserve some of the blame, okay? Here's the reality. The reality is the American people are very deeply and closely divided. And so that's why one house of Congress is controlled by one party and another house by another party. And so we're not doing anything, but okay, but you're not going in the wrong direction. Now, you take a parliamentary system. Since you're asking a fundamental question about whether the system is broke, did people in the last election really vote to let Scotland go? Because I didn't see that, but that apparently, and there wasn't a majority. David Cameron didn't get a majority for anything. In fact, there were 3 different parties, and no one got a majority. And then after the election, there's just like a bunch of horse trading. You had no idea in that system whether after that election you were going to get a coalition of national unity between the Tories and Labour in the middle, or a left coalition of liberal Labour, or what we ended up getting, which is kind of weird, liberal and conservative. So in a parliamentary system, they can do all sorts of stuff, and they don't really have a mandate. And a soft election, not that many people show up. So ours is a system in which, yes, it's kind of hard to do stuff if the people aren't for you, and we sample them in these different ways, 6 years in the Senate, 2 years for the House, 4 years for the presidency. Sometimes it's in districts, sometimes it's statewide, sometimes it's national. That's because there's no one perfect way of counting votes. But part of the problem, and you can't quite blame Congress, part of the problem is you all are divided. We are a deeply divided country on a bunch of things. And our government is, to that extent, sort of still a reflection of the citizenry more generally. And they're not going to quite say that because if they basically say it's your fault, you're going to blame them a little bit more. But I'm not running for anything, but as an academic, as a political scientist, I think Congress shares plenty of the blame, and so does the executive branch, and money in politics, but some of it. So money. Here's why money is so powerful, because actually you all aren't paying attention. So these ads actually influence you. They have to make no difference to me, because I actually know what I believe in, and the more, I'm a Democrat, the more Mitt Romney spends, the less I like him. Linda McClain, she ran for the Senate. She spent a ton of money. Oh, I was so delighted. She's pumping all this money in the economy, and I still vote against her. It makes me feel good. And secret ballot, okay? That's actually the ultimate campaign reform. It's secret ballot. So if money matters hugely in politics, it's partly because ordinary people aren't paying attention. Because if they were paying more attention, all these ads actually wouldn't have much of an effect, because you would know what you really think. So yes, blame them a little bit, but truthfully, we have to hold a mirror up to ourselves, truthfully. Oh, don't let anyone see you clapping for that. That's not going to help you, my friend. Back with the folks. Let me take the blame for that.
So
We actually
Akhil,
took up for Tim Kaine and clap for the Democrat.
So,
I think we.
so Akhil stole my thunder on that. I was going to make the point that the people suck, but I'll actually amplify it only by pointing out that one institution that we don't poll public confidence in is the public. And and it would, I don't know how you would design a poll, but to do that. But if you believe that all of these institutions, which is the ultimate proposition of the Constitution, right? That sovereignty is popular, and that these institutions that we poll our confidence in their performance are exercising delegated sovereignty from the people. It seems like it's a valuable question whether we have confidence in one another as voters, as decision makers, as electors. And I think I've never seen a poll that tries to do that. And I'm confident the answer is that the people would probably do better than Congress, but less well than the president.
So in a moment, we're going to take questions. And so if you have questions for the panel, I'd encourage you to go to either of the microphones on the side of the room. But before we do that, and as you're lining up, let me ask you this. So 50 years out, what are the changes that you see on the horizon, either through case law or structural changes to the Constitution itself, that we really need to think about making as a people in order to stay relevant, to keep it viable, and to make sure it's still working?
Well, I think that one of the greatest challenges we face goes to the heart of the approval rating that we're talking about, and that really is that Congress over the last 10, 15, 20 years, for a long period of time, I think, has been giving its power. We know how the Constitution sets out the separation of powers between Article 1, Article 2, and Article 3, and I feel like over the last couple of decades, we have seen an increasing move from having what I would call legislative activity migrating from Article 1 to Article 2. Now, why has that happened? Well, first of all, Democratic and Republican presidents over the years have wanted to accumulate that power because it's easier. It's easier to operate if you don't have to go through all those people that nobody likes over at the Capitol. But you might ask, well, why in the world would Congress give up that authority? Why would they be so willing to give it up? Well, I think we have an election in November, right? People, and I think it's amazing because those of us who are members of Congress, we work so hard to get elected. We ask for the job and work very hard to get it. And then so often when members of Congress come to and senators, I want to make sure I'm talking about everybody. But when the elected officials come to Washington and you want them to vote on something, you can't find them. They don't want to vote. They don't want to be held accountable. It's just a lot easier to let the administration do that, or let an executive agency, the EPA or the FDA or the U.S., let them take care of the business. Again, going back to my time as a state legislator in the Virginia General Assembly in Richmond, one of the things that I loved about it, I was on the Courts of Justice Committee, which is sort of the Judiciary Committee of the House of Representatives. And we'd all be sitting up there. I think there were probably 20 of us, not 60, but 20 of us sitting on the dais, 18 probably. Any member of the public could address the committee during the process of working through a bill. So a bill is called up, and it goes through the process, and any member of the public could address the committee and look at the chairman and speak to him, speak to her. That's pretty powerful. Can you imagine that happening in a committee room in Washington, D.C., where any member of individual citizen comes up and is able to have that platform? So I say all that just to say that being able, when you have a constituent come up to you as a member of Congress and complain about something that's taking place, isn't it easier just to say, oh, you need to contact somebody at the EPA about this? I didn't do that. Well, that's a problem. And so I think that what we've seen, if you go up and down Constitution and independence, and look at the massive monuments, I call them monuments to bureaucracy and executive power that have been built in this town. And you think about the tremendous resources that the private sector and those who want to lobby their government, they spend, not to lobby members of Congress, but to lobby executive agencies to get what they want. You think about that, and I think that you see readily that on this course, I fear that executive, and it filtrates through the issues that you all have talked about, especially as it relates to the war powers issues. But I think that's something that we have to rein in, and I don't know what the answer is. I think that our Constitution is durable, but going back to what I think Akhil said, at the end of the day, we as American people, I think, have to think about this and think about how we change that from in terms of who we send and what we expect them to do, and that we don't want to live. Why was our country founded? Our country was founded for probably a lot of different reasons, but certainly an overbearing monarch was one of them, if not the main reason. And so you look at what we have today. You look at who makes the decisions. Those are sort of interesting to think about, a little scary. And so when I think 50 years out, I fear that if we keep on this getting the balance between the Article I powers and Article II powers, when we let that get too far out of whack, I think at the end of the day we're all, and this should be, and it should not be a Republican issue or a Democrat issue. It should concern everyone. That is getting out of whack, and what are the consequences? How do you fix it?
We should have mentioned earlier that Congressman Robert Hurt actually sits in the seat of James Madison, the 5th District of Virginia.
It's all been downhill since, as I like to say.
I think
he was elected. So he was. Can I ask the audience a question? So who can tell me? So in 1789, this first election for Virginia's 5th District, and regrettably, Montpelier has been redistricted out of the 5th District. It's no longer in the 5th District, but it was then. And so Patrick Henry, of course, drew this district that there's no way James Madison could have gotten elected because of all the anti-federalists, and he did anyway. But does anybody know who he ran against? I guess yeah, he knows. Everybody knows. James Monroe, which is a truly remarkable and wonderful thing to think about. But thank you.
Thank you. Ben?
I would just say over the next, I don't know if it's 50 years or a few years or a number of years, we're going to two huge challenges, both related to technology. We used to have an understood compromise about surveillance, and the last year and a half has shown that we no longer have that understanding, that the basic contours of the compromise was the government can vacuum up everything it can get as long as it's outside the United States. Inside the United States, if it wants to conduct surveillance against somebody, it needs a warrant. I think what the last few years of debate has shown is that both for technological reasons and for reasons of the cultural infiltration of technology into the sort of pervasive everyday life of the average person, those distinctions are no longer stable. We don't believe in them anymore on a consistent basis. And the question is, what replaces them? Some of that is going to be constitutional law that answers that question. And I don't know whether that's going to be in the long run in the form of case law, or in the form of some form of constitutional amendment, or probably at the more what the other countries call basic law, which is statutory law that is so firmly entrenched in our consciousness that it acquires an almost constitutional level. But these are areas that whether you think about them as fundamentally surveillance issues or fundamentally privacy issues, they're issues that we've opened up a huge fissure in the society that's getting wider, not narrower. And I think the Constitution is going to have to adapt to that one way or the other. Second one, which is not an issue, it's issue specific, which is government takes too long now. And the question is, how do you have a legislative and regulatory processes that operate at the speed of, with enough speed to be relevant given the pace of technological development? And these are, I quite agree that the Constitution was designed for the legislative process to be hard, and that means slow. But we have run into a point in which we have all these issues where by the time you reach any kind of legislative consensus, the point is moot. And that problem is getting worse and worse and worse across a wider and wider range of areas. And just the structural question of how do you, without undermining deliberation, speed things up and make governance operate at the speed of the society that it's governing is going to be a very, very difficult question over the next few decades.
Akhil.
So 227 years ago, the framers created an audacious continental democracy, the likes of which had never been seen in world history. Democracy had existed only in tiny little city-states. What was basically being proposed was nothing less than world government for a new world, for a continent separated by vast oceanic moats from the ancien regime, from the old world. If we take seriously that and we project things forward, you have to think. Our children have to think about regional and global systems of government, because actually problems and opportunities exist on a global scale, whether we're talking about pandemic viruses or international terrorism or nuclear proliferation or climate change. And so if you, thinking about these regional, intercontinental, even global systems of constitutionalism, remember I told you, we were the only democratic project going 227 years ago. Now half the planet is democratic on an American model, so that's what the next 50 years, that will be a serious conversation. Domestically, here are the three rules, prescriptive and descriptive, that I put forth for constitutional amendments. They should add to liberty and equality, not detract from them. All the amendments thus far, except for prohibition, have done that. Prohibition was not a great success. So flag-burning amendments, making it a criminal thing, restricting First Amendment freedoms, not a great idea. I don't think actually restricting the First Amendment in the name of campaign finance reform is such a great idea either. Amendments should add to liberty and equality. One man, one vote, one man, one woman, marriage. That restricts liberty and equality. I don't think that's such a great idea. I don't think actually it fits our tradition. Amendments should add to liberty and equality, not take away. That's what we've done thus far. Amendments are going to have to be supported by both parties, because you can't get 2/3 of the House, 2/3 of the Senate, 3/4 of the states unless both parties are on board. States are going to have to road test all these ideas first. Every single thing in the Constitution, virtually, states did first. States had written constitutions first. Massachusetts put the Constitution to a vote first. States had 3 branches of government. States had bicameral legislatures, single-member districts, 2 past the post. States had bills of rights. States got rid of slavery first. States let women vote first. States let blacks vote first. So states are going to road test these ideas. It's a Brandeisian model. What would pass these descriptive and prescriptive tests? Well, you could imagine a direct election of the presidency, because that's actually an equality idea. All the states have little mini presidents. We call them governors. In none of the states do we have a little electoral college. It's one person, one vote. I could imagine both parties supporting this, because actually the Republicans will increasingly come to understand that the electoral college disfavors them going forward, and the Democrats like one person, one vote. They like the equality idea. So that could happen. People who were not born under the flag can be governors in the states. Arnold Schwarzenegger, Jennifer Granholm. I could imagine Republicans getting on board with their version of the DREAM Act. As you come here, you want a fence, we want a big fence, we want an electrified fence. You know, did we say we want a big fence? Okay, fine. But now what else do you have to offer? They're going to say, well, you come here and you actually play by the rules. You came here legally and you contribute for 30 years. You should be eligible to be president. Orrin Hatch proposed that 10 years ago. He still believes in it, I think. He just can't say it yet, but eventually he'll be able to say it, because it will be in the Republican Party's interest to have an alternative for that. States have formal ERAs for no discrimination on the grounds of sex. I think it would be nice to have that in our federal constitution. It's already there implicitly, but let's say it again, this time with feeling. States are giving us a gay marriage, and sometimes in state constitutions, and I could imagine actually that being something, because both parties eventually are going to find it in their interest to do it. It adds to liberty and equality. States are doing these things first. So those are the 3 principles. And those are both descriptive and prescriptive principles.
So why don't we take some questions? We'll start over on this side. Please introduce yourself. Let us know who you are.
I'm Ellie Pugh, and do you think that the Constitution will ever be completely rewritten? And how far in the future do you think it will happen?
Can I say something to Ellie? I met you, Ellie, at the reception, and you told me you're 9.5 years old. Is that right? I think I came for the very first time as before adulthood to this building when I was 9.5 years old. And it changed my life, this building, the National Archives. So thank you, David, for that. Now, Ellie, you should have your parents give you a $1 bill. They'll do it. I met them there. And on the back, you see there's this pyramid, and it's unfinished. I think America's constitutional project will keep going on. When it says it's a more perfect union, but I don't think we'll ever get there. We're always building. I don't know if we're going to actually rewrite the whole thing. It's interesting. We've added amendments to the end. It's like James Madison called it a careless written letter. It's so many postscripts and post PPSs. They didn't rewrite the thing. Most state constitutions actually, when there's a new amendment, they kind of word process the thing. They rewrite the main text. But here, we just say, oh, and another thing. Oh, and another thing. And we just kind of add them. So I'm not sure we're going to rewrite it. We haven't done that since at Philadelphia 227 years ago, but we're going to add a bunch of amendments, and the pyramid will keep growing and growing and growing, but I don't think we'll ever get there. I don't think it'll ever be perfect. But I do think that your generation is going to have a lot to say. You have to figure out what you want to put on top, as the next layer of that pyramid. Do you know, can you tell us what the preamble of the Constitution says? Do you know a little bit about it?
It says, "We, the people of the United States of America."
That's a very good start. That's like half of the Constitution right there. But here, so we, the people of the United States, ... we do ordain and establish the Constitution. That's what began 227 years ago. But here's one little piece of it that was written actually just for you. It says, to secure the blessings of liberty to ourselves and our posterity. They were thinking about later generations, but they were thinking about you. And you have, I think, obligations to them to try to make the Constitution even better for your children, still unborn, and so that's actually the challenge of your generation. That's what I believe.
Yes, sir.
Make sure they give you that dollar bill.
Yes, pending in the U.S. District Court is a civil action to enforce the malapportionment penalty of the second section of the 14th Amendment to reduce the representation of representatives in Congress in states that award their electors on a winner-take-all basis that is not grounded in state law. In the former Confederate states, that's North Carolina, South Carolina, Georgia, and Alabama. Why is this provision? Well, this is to correct the 15th Amendment, which is working for the Caucasian, but is not working for the non-Caucasian. And we can correct that by enforcing that provision of the Constitution that was championed by the abolitionists that punished former Confederate states to disfranchise the new those former enslaved by reducing their representation, not allowed them to sit in Congress until they granted that franchise to those of African descent before the 15th Amendment was even in the Constitution. Why is it that progressive organizations are not trying to enforce this provision of the Constitution? It's Gordon versus the clerk of the House of Representatives. I'm the Gordon.
One of the most interesting things about the written Constitution is that it endures. There are clauses, they are dormant. They're not enforced for long stretches of time. But then, like Sleeping Beauty or Rip Van Winkle, they do have the ability to reawaken and be re-energized. When I went to law school, people used to kind of scoff about the 10th Amendment. It was kind of a punchline to a joke. And now there are lots of people, but it was in the Constitution. So people, and so it always had the possibility of being reinvigorated, as it, I think, has been legally and politically. 15 years ago, not so many people thought the Second Amendment meant much of anything. There was very little case law about it, but it's in the written Constitution and has this capacity to reawaken. There are still clauses for long portions of time. Lots of the 14th Amendment, even Section 1, wasn't really enforced. And then the Warren Court came along. There's a part of the Constitution, the Republican form of government, hasn't been very robustly judicially enforced. There's a lawsuit right now in Colorado actually trying to make it justiciable, make it more enforceable. Section 2 hasn't been enforced of the 14th Amendment. It's conventionally thought for a very long time. We actually have the world's expert on Section 2 of the 14th Amendment here. It's not yours truly. It's actually a student of mine who wrote a brilliant paper on this. He's sitting right next to you, so you should ask Tom Schmidt. Raise your hand. He wrote a great paper on this, and raise your hand, Tom. Okay, you can talk to him afterwards because he wrote a paper on this dormant clause of the Constitution, and you should talk to him afterwards about what happened to that clause. So,
invite me to Yale. I can make a presentation on this, and I can interact with him because I.
Well, Tom is now at Columbia, but.
Next question.
Thank you. I'm Leonard Oberlander, and I would like to hear some views on whether or not two seminal factors are helping to make the Constitution work or not. One is from the Supreme Court, the statements that Supreme Court justices' decisions will be made, including personal conscience. Someone said, I will not make a decision without my personal or without a matter of conscience. The second is whether Supreme Court decisions should be made on the basis of international court decisions, which is something that was never, neither of these was ever, as far as I could see, mentioned in any of the papers that was circulated to the people when the Constitution was written, or even very long after that, until this particular decade. Thank you.
I'm not an expert in the Supreme Court, and I'll defer to my colleagues for their answers. But I will say this, certainly on the first question, that this the part of why the Constitution is so important, and why I think the marriage of our constitutional Republican form of government, the marriage of that to a free market economy, has been so successful is because of the rule of law, because of private property rights. Those are the things that have made this country so successful over the last 200 plus years, have made this country so prosperous and wealthy. And so I think it's important to point that out. The reason I say that is I believe that judges must follow the law. They must follow the law. And when they fail to do so, I think that they jeopardize our entire constitutional system. And if they find themselves in a place where their personal conscience is at odds with following the law, then they need to step down from office. They shouldn't be allowed. They shouldn't allow themselves to have that.
On the foreign law point, this has been the subject of a very heartfelt debate over a fairly protracted period of time between Justice Scalia and Justice Breyer, both of whom have spoken about it. They've talked about it, I think, together, actually, in public, and they've, I think, sniped at each other in written opinions on the subject as well. And I think, with all due respect to Justice Scalia's view, the Supreme Court uses as non-binding sources of law everything from the opinions of academics in law review and non-law. Law reviews are edited by students, right? So if you say, is it a legit, it is indisputably, to this, 9 justices of the Supreme Court would accept that it is a legitimate non-binding source of law to cite in an opinion that binds the lower federal courts, the Congress, and the president, the opinion of a single scholar edited by students at a different university.
Is this a great country?
Yeah, right. Like,
Wow.
That's a legitimate source of law. But the considered view of a foreign tribunal that has confronted a very similar issue under a legal system that may be very similar to ours is not sort of a verboten source of law. And I think that's got to be wrong. That said, if you look at the issues that Scalia is complaining about, they have a certain merit to them. And the issue arose because in a series of Eighth Amendment cases, there was a tendency in deciding whether something was cruel and unusual to look around the world and find all the courts that had agreed with you everywhere and say, look, there's a consensus. 25 states have banned this thing. A lot of polls say it's banned. And by the way, the Supreme Court of South Africa said the following. And there's something very mischievous about that as an interpretive methodology. And so for what it's worth, my view is that Scalia's argument has a lot of merit in the specific context in which he raised it. But the proposition that he draws from it, which is that, it is uninteresting and irrelevant to all discussions of how we should understand U.S. law, how other tribunals have considered similar questions elsewhere, has got to be sort of an overbroad way to think about it.
Gentlemen, I'm in the unfortunate position to draw our panel to a close, but let me say, on a Constitution Day, 227 years later, I think what you've reminded us is that the conversation continues throughout the country. And as you suggested, Ben, the conversation is happening globally as well. So I don't think we could do this tonight without reminding ourselves, because it's come up a couple of times. Some friends of ours in Scotland go to the polls in just a few hours, and I just wondered very quickly before Kat Imhoff closes us out, up or down, how do you think it's going to go? Are we better together?
Are you asking for a normative view or a prediction?
I would love the prediction. How do you think it's going to go tomorrow for the Scots?
Oh, I think it's looking bad for unity. As much as I hate to say that.
People are in a sour mood all around the world, but I think that would be unfortunate.
I agree it would be unfortunate. Yeah, I think it'd be a tragic mistake, but it does look like from all reports that it certainly seems to be headed that way, but we shall see.
We shall see. Gentlemen, thank you very much.
Thanks. Thank you.
So I am indeed Kat Imhoff, and I have the great pleasure of being the president and CEO of the Montpelier Foundation, which is home to the Robert H. Smith Center for the Constitution. This has been a wonderful evening. I want to thank our co-host here, actually, David. This is the National Archives. You've just done a wonderful event. We love doing this with you. And of course, the Claude Moore Charitable Foundation has been our supporter, and our panel. It was a brilliant evening all the way around. Thank you, especially to my colleague, Doug Smith. Akhil, Robert, Ben, you have challenged us mightily, and I think we all have learned that we are a work in progress. We cannot end this evening without a quote from James Madison, who noted that the Constitution ought to be regarded as the work of many heads and many hands. And I would say, of course, our Charter of Freedom continues in all of our heads and all of our hands. This is indeed Happy Constitution Day. Come visit us at James Madison's Montpelier. Be safe and be participatory. Thank you very much.